The good professor, and we thank you for joining us, sir, very, very much. It's Christopher Greene, professor of law, HLA Hart Scholar of Law, professor of philosophies, taught at the university since 2006. Also the author with works such as Equal Citizenship, Civil Rights, and the Constitution. Professor Greene practiced the appellate litigation at Phelps Dunbar in Jackson. After clerking for Judge Barksdale, the U.S. Court of Appeals in the Fifth Circuit, A.B. from Princeton, J.D. from Yale, Ph.D. from University of Notre Dame, and A.O.K. from, I guess, the credit bureau if you paid off all your student loans, but well-versed there. Good morning, sir. How are you?
Doing well. Good morning to you.
Good morning. This is interesting because I don't know of another time when we have had the spotlight pertaining to the Supreme Court of the United States where two major cases, a major case, but actually two cases before the Supreme Court. Let's take the aquifer case first of all. This has been in the news for a long time, bouncing back and forth, and apparently it's made its way into the court system now. Justice hearing arguments in person for the first time since the pandemic began. They will hear with the Mississippi versus Tennessee. What's your thoughts on this one, Professor?
Well, the argument yesterday did not go well for the state of Mississippi. One thing that's interesting about the oral arguments that they're doing now, so last year, all term, they did them over the telephone. And in order to have that be orderly, you can't see when the justices are interrupting you. What they did is they just went down the line. So the Chief Justice would start out, and then you'd have Justice Thomas, who is the senior associate justice. He would ask some questions, which he usually just waits for everybody else to use up their time, which they never really do. So what they did now, they're back in the courtroom, except for Justice Kavanaugh, who is at home participating by telephone. But they continued to go down the line. So Justice Thomas asked a bunch of questions. He was the first out of the box. And one thing that's interesting, when they are going down the line like that, you can tell right away what all of them think. And our argument about Tennessee having to pay damages because they're pulling too hard on their wells near the border, it was very clear that they're very skeptical of the claim. So what this is an original jurisdiction. So there hasn't been any trial court. This is a suit at the U.S. Supreme Court. A state versus a state can sue just straight up at the Supreme Court.
Right.
And what they do is they send this to an old friend of theirs, usually a former clerk, a special master, who has essentially what's like a trial. And we lost before the special master. So we're already pushing uphill. And it was very clear. The United States came into the case, filed a brief against us. So it's very clear from that we're pushing even further uphill. And then once we got the questions, it was not encouraging for people who were hoping to get more water for DeSoto County.
Yeah, I'm a little inquisitive about this, though. Was it to a fact there was a little bit of a frailty to this, a little bit of a humor to it, or a little bit of of why in the world is this even here? If that was the inference there, did they have to take it? Could they have just dismissed it?
I'm not sure quite what so there has been some question about whether some of the justices have said that they're required to hear any case that it comes in the original jurisdiction. The court as a whole has sometimes just said we deny leave to file a complaint. They've already filed. I mean, this is years down the road, so that stage of cutting it off wouldn't be available. The issue of groundwater. So groundwater, I don't know much of the geology. You learn a little bit of geology just to understand these cases, but it's kind of sort of like a river and kind of sort of like a lake and kind of sort of like neither. So we've got this big chunk of this aquifer. All this water underneath 8 different states. And the rules that apply to that aren't perfectly clear. I think the justices think that they'll take the rules for rivers and apply it to them. That seems to be what they're inclined to. There has been some scholarship where they suggest some people suggest that's not a perfect analogy. So there were some questions about, well, does the speed at which the water is moving, does that matter? If it's really, really slow, does that mean it's sufficiently unlike a river? And then there were some questions, well, what if it's like a lake on a state boundary? Are you crossing a boundary if you're just pulling at one side of the lake? That sort of issue. So just the general principles applying to aquifers are something that they might say something significant about. They could also,
let me ask you this.
Say, look, you don't get damages.
Yeah.
All you get is an apportionment.
Was the pump where Memphis was pumping this? It wasn't in Mississippi territory, though, because there was one story that said the pump was on Mississippi land or in the boundaries of Mississippi. I guess that would have been a wholly new thing, but was that the case as far as you know?
They seem to say that it's possible that was a contested aspect of the facts, or something that they're hoping to raise in the future. I think they were chiefly talking about things that were. I mean, Memphis is right on the line, of course, and it's very densely populated right from the state line. I think they were saying they were just right on the. Right next to the state line, or close enough that it would produce enough of a hydrological effect that would be direct and predictable and too much.
So where does it go now? Is that it, or do we have another day of argument, or is it over?
So what they do with argument, they just have 1 hour of argument, and then we wait for them to come out with their opinion. This was the very first argument of the term. Usually they get out maybe 2, 3, 4 cases in the calendar year, the October and November sittings. Given how much they seem to agree with each other, they didn't seem to think this would be a particularly difficult case to resolve against us. It could come out in November or December. If it suddenly becomes difficult for them, if they have a dissent they've got to reply to, it could take months later. Almost all the time.